The land, the animals, and the people. Welcome to the Wolf Connection Podcast.
It is my pleasure to welcome back for the third time on this podcast, as we were talking just before, and also celebrating her 4 years at Wild Earth Guardian. She is the carnivore coexistence attorney, and we're here to talk about the recent ESA ruling for wolves in the Northern Rocky Mountains. She is Lizzy Pennock. Lizzy, it's great to see you again. How you doing?
Good. It's good to be back. Third time's the charm, hopefully.
Yeah. Well, there's always something important that we seem to discuss every time you're on here, and you're a great legal mind, and you're able to really sort of break these things down in ways that everybody who's listening can get the information that they need to understand what the ruling is, because when we read legalese and we look at something that's 105 pages, it might not make sense.
Same. I see 105 pages and I'm like, okay, here we go.
Here we go. Yeah, exactly.
Some of this, I think legal nerds will rejoice at some parts of today's conversation, but mostly I'll try to keep it out of the weeds.
Yeah, and I think we'll do that, and it's good. And we've gone back and forth on this a couple times. So those of you that are listening, and we'll have actually the full draft of Judge Molloy's ruling, the 105 pages, in the description of the podcast. So if you're listening to this right now and you want to look at the actual PDF from Judge Molloy and go through it as Lizzy and I do, please do that so you can get an idea of what's happening. So first things first, Lizzy, just tell everybody the overall ruling. So I think people saw the breaking news. This was, I believe, August 5th or 6th, so earlier this month, that Molloy ruled that there wasn't a fair shot given to wolves of the Northern Rocky Mountains. So just give an overall for anybody who's listening and wants just like the elevator pitch of what this actually meant when he put this ruling down.
Yeah. Well, emotionally, this was a very big deal. This was a huge case. We've been talking about relisting wolves in the Northern Rockies or in the West as a whole for a long time. And for me, it felt like it could be a long shot. I just feel like in this work, the cards can be so stacked against us and against wolves. So this was a huge deal. I think an important nuance is that it's not just Northern Rockies wolves. So the background is many groups, conservation groups, petitioned the U.S. Fish and Wildlife Service in 2021 to essentially relist the Northern Rockies population, or to create a new, distinct population segment, which is what the Northern Rockies, that's a distinct population segment. So this is an entity under the ESA which can be listed. And they said either relist the Northern Rockies distinct population segment or create a new distinct population segment that's all wolves in the West, all gray wolves in the West, and list that.
So would that basically include, because I know sometimes it gets a little tricky depending upon what we're looking at, when they say a new distinct population, including the Northern Rockies, are we also including Eastern Oregon, Eastern Washington? California I know is already listed, but are we talking about those segments as well, and even some in Nevada and Utah? And
all gray wolves in the
all gray wolves. Got it. Okay.
Except, so not Mexican wolves, but all gray wolves.
All gray wolves. Got it. Okay. So that was that's the overall idea.
Right. And the reason that we asked for that is because, in the past, especially 30 years ago, when wolves were listed in the first place, we had a very isolated population in the Northern Rockies, which, makes sense then to list that entity.
Right.
Now that population is connected to the West Coast and connected down into Colorado, which the Fish and Wildlife Service said, many times. So that's going to be a big part of our conversation today is connectivity. But when populations are no longer discrete from other populations, it makes sense to consider them as a whole. So that was the argument for the Western population. So we filed those petitions. The Fish and Wildlife Service in 2024, the 2024 finding, that's like the action we challenged in the lawsuit. The agency said there is no longer a Northern Rockies distinct population segment. The correct entity to look at is west-wide gray wolves as the new distinct population segment. But we, the Fish and Wildlife Service, determined that those western wolves do not warrant ESA protections. So we challenged in this lawsuit their determination that western wolves do not warrant protections. We did not challenge their determination that the correct entity to consider is western gray wolves, as opposed to just the Northern Rockies.
Okay. And so what did Judge Molloy, and so Judge Molloy went back and, again, correct me if I'm wrong. So what was his ruling then was for the Federal Fish and Wildlife Service to go back and consider listing all gray wolves now in the western part of the United States as one entity under the ESA. Is that roughly what it is?
Yes. And that's what they did before in their 2024 finding, except based on their analysis, they determined they don't warrant listing. So we challenged the analysis that they rested that determination on. So this order, the 105 pages of this order, is a very comprehensive dive into the problems with that analysis and the arguments back and forth over the adequacy of all of the facets of that analysis that underlie the not warranted determination.
Got it.
So the service has to go back and redo that analysis for the Western DPS while fixing all of the errors that Judge Molloy pointed out.
Right.
And we'll get way more into that.
Yeah, we're going to get into that. Yeah, we'll dive right in because there's a lot to cover. For just anybody who's listening out there, and for myself as well, because I want to know this too, and this is the second point we bring up. Define for anybody who's going to be reading this too, and obviously they'll be following along, hopefully with you and I, just define quickly what arbitrary and capricious means throughout this ruling, because it's used a fair amount by Judge Molloy. So what does that legal term mean when you put that into context throughout the document?
Mm-hmm. So big picture, when you file a lawsuit under the Endangered Species Act, the legal standard is under the Administrative Procedure Act, which provides legal hooks to challenge agency actions. So when an agency here being the U.S. Fish and Wildlife Service, when that agency makes a decision under the ESA and we want to challenge that decision, we're challenging it under the standards laid out by the Administrative Procedure Act. So the APA directs courts to hold unlawful and set aside agency action, findings, and conclusions found to be arbitrary, capricious, or not in accordance with the law. So what that means, so that's kind of the standard that the judge is using to look at all of the agency's actions and findings and conclusions. So an agency action is arbitrary and capricious if the administrative record demonstrates that the agency relied on factors that Congress, aka the law, did not intend for it to consider. The agency entirely failed to consider an important aspect of the problem, which comes up a lot. Right. Or the agency offered an explanation for its decision that's counter to the evidence before the agency. Or the agency has come to a conclusion that's just so implausible that it's like ridiculous and couldn't be ascribed to like a difference in a viewpoint. Or, sometimes agencies, like, and this will come up too when we talk about science, like agencies tend to get deference when there's a battle of the science, because the agency has expertise in this field. And so sometimes an agency will get deference just because it's like, well, yes, that science did disagree with us, but this is our view. And we have a different view. But sometimes the record doesn't support that view. It's just like completely implausible. So that would also be arbitrary and capricious.
Got it.
And just to give more context this is a little bit of the weeds, but we're talking about the administrative record. So an agency action is arbitrary and capricious if the administrative record demonstrates that the agency, did any of those things on that list. So when we are talking about a lawsuit where we've challenged a federal agency action or decision, the universe of that lawsuit is limited to what is called the administrative record. So U.S. Fish and Wildlife Service, has all these papers and communications and things that it considered and draft publications of, analyses and findings and all of these things that the agency has considered when it's going through the process of coming to its ultimate decision. That's the administrative record. So when we challenge that ultimate decision, what's before the court is just that administrative record.
Okay. Got it. So that's what we're diving into then now. And when you, and this sort of goes in the point that I was mentioning in this first part here is describing if anybody who's listening and you look at page 23, you highlighted a portion here and what that means. And Judge Molloy cited in this instance, in the introduction and the political yo-yo process, and you and I think, me and Stephen have talked about this, and we've discussed this on the podcast, I think, at length, is the way that gray wolves have been treated specifically in the way that they have been yo-yoed, either listed or delisted. So talk about that part on page 23 and what he was citing in this about the reintroduction process and the political yo-yo that was happening there, with the listing versus delisting and what that means.
Yeah.
And why he came to that.
So, the part I highlighted on 23 is basically kind of that legal standard we were just talking about.
Right.
And like you said, he is talking about that in the context of like this political yo-yoing. So, and he says, as the ESA intends, a science-based approach negates this political yo-yo management dilemma. And that dilemma is basically like wolves get wiped out, wolves get listed, wolves recover to some extent, wolves get delisted, wolves get wiped out, wolves get listed, that's the yo-yo process. And I think that's a theme that underlies our petitions because we know what's happening in Idaho, Montana, primarily.
Wyoming,
yeah. And Wyoming's always been terrible.
right.
Idaho and Montana have not been great, but they are worse now than they have been. So that, if we were looking at a science-based approach, it would be different than the political-based approach I think that wolves have been subject to, which is calls from very powerful groups with a lot of political sway, like big ag and like trapping groups and trophy hunting groups. They are very well funded. And those are the people that don't want wolves to be protected, or they want to hunt wolves, and then they want to hunt wolves so much. And then kind of the state agencies are captured by those groups. And then, we get into this process where it's like, and Judge Molloy says, like managing to the extinction threshold. And this is not how we should be doing it. This is not the way to manage a recovered species.
Right.
Yeah.
And he kind of brings that to the forefront in a couple of different parts, is that and we'll get into this a little bit more as we go down the list here. But just as a precursor is that the numbers, and I was listening to the hearing, I think the first 2 or 2.5 hours, and you could hear in Judge Molloy and some of the arguments that were made by the U.S. Fish and Wildlife Service that the numbers genuinely did not add up in his mind, and seeing how looking to go, like you say, to the extinction threshold and then trying to yo-yo that process back. And then that gets into genetic diversity and connectivity, which we'll also go over. But what were the main arguments that, Wild Earth Guardians and a couple of the others brought to this particular point before we move ahead about the political yo-yoing? Was it merely to bring this up and say, this is not, obviously, as many people I think know who are in this space, this is not a good way to manage any species, let alone one that has been extirpated from the majority of its habitat in the western part of the United States, and then trying to recover that species and then have connectivity and also have genetic diversity. It just doesn't work that way in the way that the politics are working.
Yeah. Yeah. So we made like 3 buckets of arguments, essentially, because there were 3 lawsuits that were consolidated. We were one of them, represented by the Western Environmental Law Center, and we had other people in our group as well. So each group covered a certain subset of arguments, but the political yo-yoing and the state mismanagement came up in a few of them, including like you said, looking at, genetics and genetic diversity, and how the increased mortality from increased, I hate the word harvest, but I'm using finger quotes here, regulated harvest, increased mortality from that, how that's going to impact dispersal and genetic connectivity and the ability for us to continue in the future to have this kind of meta population like we were talking about across the West. And then a whole bucket of arguments was also looking at the threat to wolves from existing regulatory mechanisms. So when the Fish and Wildlife Service considers whether to list or delist a species, they consider 5 factors. One of those factors is the adequacy of state regulatory mechanisms. So that means looking at how the state is managing the species, including laws at the state level and seasonal regulations at the state level and things like that. So this is going to come up a bunch, and the political yo-yoing, also comes up in looking at. I mean, the politicized nature of wolves in the Rocky Mountain states is part of the order, and it's about the service needed to fully consider how that would impact the future of wolves in the entire West.
Right, and that gets to when we get to the next part, and this was the argument I think I heard most often. I think in the beginning part, because I was not there for the entire hearing, but I do remember this discussion when we get to, and this is one of the main points I wanted to touch upon, is discussing the range and discussing when we're talking about current range that is mapped out by entities now with about gray wolves, and then discussing about historical range. And that was something it looked like Judge Molloy really took a harder look at. Correct me if I'm wrong, but it really did seem like this was something, and there was a 3-fold analysis on page 36 of his ruling, and this is where you wrote back here on my outline that I sent, is the discrepancy within the ESA over range meaning. And so just really go into that a little bit about why this is such I guess a difficult topic to wrap your head around, because when you look at the range of gray wolves historically, obviously they covered the majority of North America and what we now know is the United States, Canada, and probably some of Mexico. So how does that play into this ruling also in the way Judge Molloy ruled in going about this 3-fold analysis of current range as mapped out by state management, federal management, and historical range, and what does he want to see be revisited in that way, if that makes sense?
This is where the legal nerds will rejoice. So there's the legal part of this discussion, and then there's the effects on the ground part of this discussion, and they'll be kind of intertwined. And the reason that Judge Molloy was so interested in kind of getting to the nuts and bolts of what is range is because of all the legal stuff that is going on. Please stop me for clarifying questions or if I'm getting too far into the weeds.
Sure, you got it.
But when the service, has to consider whether the gray wolf in the Western distinct population segment should be listed, it looks at, is the, in this case, not a species, but the Western distinct population segment, is that DPS in danger of extinction or likely to become in danger of extinction in the foreseeable future throughout all or a significant portion of its range. So range is a really big deal.
Right.
That's like the whole area we're looking at to figure out whether or not to list this species. The reason that so much kind of felt like up in the air, or Judge Molloy was trying to figure out like where to go here, comes back to legal interpretations of that word. So here, the Fish and Wildlife Service considered only occupied range, which really narrowly constricted their analysis.
Which is what they're occupying currently at this moment.
Currently occupied range, okay. Which, as you said, is very tiny proportion of their historic range.
Correct.
Plaintiffs argued with us, we argued the service needs to look at historical range and occupied range. And the service said, no, we have this 2014 policy where we defined range to be current occupied. And that's what we're relying on. We said, no, the Ninth Circuit Court in 2001 defined this word range, and you should rely on that, which is what we asked for, current and historic. Where this gets tricky, and some people may be aware of what has been going on with the Supreme Court, overturning longstanding legal doctrines. One of those is the Chevron doctrine. So range is ambiguous, right? The word range is in the Endangered Species Act, but the Endangered Species Act itself doesn't say historical range. It says range. So then under Chevron, when a law leaves something ambiguous, it is then up to the agency implementing that law to create its own meaning for what that ambiguous statutory language means.
So it's basically, in a sense, simply it's a loophole that's been, I wouldn't say it's a loophole, but it's ambiguous from the start, in that there's no way for anybody, like wasn't again defined in the ESA. Like if they would have said current or historical range as of when the ESA took place, that would have obviously meant different than where we are over 50 years later.
Right.
With the ESA.
Right.
If they would have defined that, but they didn't, it was just range. And so now it's up to whoever is running the agency to define what that is. Is that kind of where? Okay.
Yeah. So the agency says, look, this is how we define range. And under Chevron, which directed courts to then defer to agencies' interpretations of ambiguous law language. And so like in 2018, the Ninth Circuit said, yeah, we're going to defer to that definition of range.
In the 2001 or the 2000, which ruling?
Sorry, this is getting confusing.
It's okay.
So we said you should use the definition from 2001.
2001, right. Okay.
Which is current and historical.
Right.
Which predated the service's policy in 2014 that they should consider only current occupied range. Mm-hmm. A subsequent court decision in 2018 under Chevron deferred to that 2014 interpretation. So the service said, you, Judge Molloy, must also defer to that interpretation.
Got it.
But Chevron, which was the legal underpinning for the deference to that interpretation, got overruled. There's a whole page in this opinion, which I found great joy reading, which was like quoting the Supreme Court's opinion in the case called Loper Bright, where they overturned Chevron, and how Chevron and the Administrative Procedure Act just don't go together. And courts, like, it just doesn't make sense to defer to agencies' interpretation of a law. Like, that's crazy. Judges decide what the law is. So he's like, clearly, I should not be deferring to what the agency said the law means. I'm going to be deciding what the law means. And based on, he did a very comprehensive statutory analysis of the language of the Endangered Species Act. And there's this whole legal framework you use to figure out what the law means. And it's, what were the Congress people saying on the floor of Congress when the law was being discussed and passed? And like, what was the intent behind the statute? And what is the purpose of the statute? And we know with the Endangered Species Act, it is like the most comprehensively protective law of wildlife ever. Like it's the gold standard. So it's in that context that one must consider range. And okay, so are we following?
Yes.
Okay. So that's the legal backdrop that in my opinion, Judge Molloy was trying to figure out what was his authority with the changed legal doctrines to interpret range in the way that we argued it should be interpreted. And he did that whole comprehensive analysis and said, yeah, that's what the law means. That's what it's supposed to mean. It's not up to the agency anymore to define what the law means. It's up to me.
And so go ahead.
Well, he gives this really interesting example in this case. He's like, the ridiculousness of the agency saying we should only consider current range is really well demonstrated by gray wolves themselves. If we had, kind of like you said, looked at the 1970s, like we would have never considered the Northern Rockies as a significant portion of their range because they weren't there.
Right.
Now, the Northern Rockies is like the whole keystone of the entire Western population of the gray wolf. So It's like, why would we consider only what is and not what could be when we've seen how much that can change?
And what was. And I think that's what it seemed
and
like.
What was. Mm-hmm.
Right. It seems like he was really pulling all those things together in reading and trying to understand what I could in this. And for those of you that are listening to us, is that Judge Molloy is saying, well, there is suitable habitat within this range that still isn't occupied at this point, or at least occupied to, population thresholds and things like that, which we'll get into in just a minute. But yeah, it really was interesting for me to see that Judge Molloy took that stance and saying, we can't just consider where they are right now, because if we consider where they are right now, if we revisit this in 5 years or whatever, depending upon, again, the political yo-yo that we talked about just before, this is an ever-shifting process, and you can't prescribe to the ESA. And ultimately, I think, and you can let me know your thoughts about this too, Lizzy, but the ESA is not something I don't believe was intended for these species to live on forever.
Yeah.
I think it was to get those species. We are going to try and protect and conserve and help rebound species so that ultimately they can come off of the list.
Right.
But it's that major tool that we're able to use so that we can protect these environments and these ecology. And it's a lot more than just the wolf itself. It's about protecting the land and the species. But anyway, yeah, it was just a very interesting way that he brought all those dynamics into part of what he was saying.
Right. Yeah, we want to recover the species, but if we know that, removing protections from a species is going to mean that states where that species live are going to manage it back to minimum thresholds for like survival, that's not what the ESA has intended to happen.
Yeah, absolutely.
Yeah.
The Wolf Connection podcast is now sponsored by our new partner, Jacques-Marie Mage. This LA-based brand is known for their limited edition, handcrafted eyewear and luxury goods, but also for their stewardship program, which supports various nonprofits and individuals who are working to protect a future for wild wolves.
I mean, discuss too, I wasn't there, or what were some of the things that were brought up? I think was this Wild Earth? Was it you guys that brought up the issues over Colorado, California population size and range, or was that the Fish and Wildlife? Correct me if I'm wrong on that. Who brought up those arguments?
Those arguments were brought by the first group, which was argued by the Center for Biological Diversity. So this was also part of the range analysis.
Part of the range, right. I wanted to bring
So the first argument in this context was how to define it. And the judge ruled in our favor on that point and said, you need to consider historical range.
Right.
That group of plaintiffs also argued that it was an error for the service to omit Colorado from the range analysis. So the service said there's 4 significant portions of the gray wolf's range: Idaho, Montana, the West Coast states, and like the Northern Rocky Mountain distinct population segment, which includes Idaho, Montana, Wyoming, the eastern third of Oregon and Washington, and a little bit of Utah. They did not put Colorado on that list. And they said, well, we don't really consider Colorado to be significant in light of how few wolves are there, and how little occupied range is there compared to the rest of the Northern Rockies. So clearly, we've already covered that just considering the proportion of occupied range in Colorado was inadequate. But this gets into a theme that ran through the whole order, which is there were a lot of internal inconsistencies in the service's analysis. And this is what gets to the arbitrary and capricious standard. So while the service said, well, Colorado's not significant and there's not that many wolves there and they're not taking up that much space, they also relied on Colorado throughout their analysis to say, well, despite these increasing levels of human-caused mortality in Idaho and Montana, the western wolves are going to be fine because, we have these new wolves, this new population coming up in Colorado. It's like, well, either it is significant and it matters for the whole western DPS, or it doesn't. You can't do both. And they didn't really explain that discrepancy.
Got it.
Mm-hmm.
Okay, so they were trying to double dip in a way,
Yeah.
and use it as a right. Okay, so that makes sense. And did they consider California in this range as well? It didn't seem like they did, even though that they're starting to naturally recolonize, the northeastern part of the state at a fairly, positive clip.
They did. They roped in the whole West Coast, so they considered
The whole West Coast. Okay.
Oregon and Washington together.
Okay.
There's one more thing that they didn't do when it comes to Colorado. They cut off their data set at 2022, and they were like, "There's only 2 wolves there," but they knew that more wolves will be reintroduced in 2023, and they just didn't consider it at all. So that was another problem.
Right. Were those some of the major things that Judge Molloy was seeing in this when he made this ruling? It really seemed like he was focused on the inconsistencies, and it really seemed like that was from a lot of what I've read, and we'll get into more. We're going to get into population genetics and stuff in just a second, but that really seemed, especially with the range portion, he was very concerned about the inconsistencies within the legal ramifications of this whole process.
Yeah, and there's another inconsistency in this context, which does bring up California. So basically, when the service considers what's a significant portion of the range, there's a few factors that they look at. And one of those factors is the status of wolves in a portion of the range. So in California, they said, or the West Coast states, which they considered altogether, they said this is a significant portion of their range because the status here is a little bit different than other areas. There's way less wolves than like the Northern Rocky states, for example, or just Montana or just Idaho. There's different ecological provinces in like ecoregions in the West Coast states that are not reflected in other parts of the range as a whole. And those things mean that is a significant portion of the range. Those arguments also apply to Colorado. And
right.
The service was like, no, we're not gonna include Colorado in that. So the plaintiffs argued, if you're going to do that analysis and make those findings for California in this way, you can't just not do it for Colorado because the reasoning applies the same. There's different ecoregions in Colorado that are not found anywhere else in the West. There's a small number of wolves. These are the exact same factors that led you to consider the West Coast as a significant portion. Therefore, you also have to do it for Colorado, and they didn't. So that was another internal inconsistency where the judge said, yeah, you needed to consider Colorado.
You need to consider that. And this, I think, ties right into where we go next, which is the population genetics and the state regulatory mechanisms, is when we talk about population data models, and this is what's happening right now. Those of you that are listening to it today, this week, Montana Fish and Wildlife have their commission meetings about their modeling and talking about population sets. IPOM came up a fair amount in this hearing about higher population counts than what are actually there. Genetic diversity, which is a major problem in Colorado, really was. And I remember early on in our podcast days when we were talking to the likes of Mike Phillips and Gary Skiba, Colorado really is that connectivity point for genetic diversity from the Canada wolves, Canada all the way down to the southwestern part of the United States, so that there is that full run of connectivity. So what were some of the scrutiny there that Judge Molloy found in sort of these estimates and these population models? Because as we've seen, and even with Montana and some of what they're proposing in terms of lowering the population sets there due to their counts, the numbers just don't seem to add up. So what was he looking at there with the regulatory mechanisms and the population genetic diversity in that set?
Yeah. So this is where the Endangered Species Act has a standard, which is that the agency must rely on the best available science. I think, many of us are familiar with this term. It doesn't, and the Judge Molloy does a good job of saying, based on the case law, like, what does this mean? Best available science. And it's not the best possible scientific information. It's the best science that's available. And Fish and Wildlife Service kind of used that here to be like, well, IPOM in Montana and Idaho's population modeling, that's what's available. And like no one else has really published anything that gives us a look at, what exactly is wrong with those things. Although we do recognize that the models themselves overestimate the population. So the best available science is kind of the lens through which we are looking at these arguments. So we argued that the service failed to use the best available science when assessing the gray wolf's current population and its future needs. So they have unreliable population estimates, like you said. They failed to consider genetic diversity. They failed to calculate the effective population size. They failed to accurately assess the current condition of wolves in the West, and then they made a lot of unreasonable assumptions about wolves in the future. So that's a long list. The judge said when it comes to considering genetic diversity regarding a specific study that we argued they should have used but didn't, they had interacted with that study enough to reasonably say we are not going to use it. So they don't have to use the science we want them to use if they disagree with it on a rational basis.
Who doesn't have to use that? The agency?
The agency.
Okay.
Yeah.
So if they don't agree with the science, then what's the compromise there to what science is going to be used? And I didn't mean to cut you off, but I feel like that's important. Yeah.
Please. So in this example, we had said you need to use Bridget von Holt's study in 2023 or 2024 that basically said we need like way more wolves to ensure healthy genetics in now and into the future, and we don't have that many wolves. The service had other studies that didn't say that, and they said, no, like this is the number that's appropriate. So the agency, in figuring out what is the best available science, when there's kind of a battle of the experts, as long as the agency doesn't ignore conflicting science, but they actually contend with it and consider it, and in this case, write a 40-page internal memo disagreeing with the findings in von Holt, then they have met the legal standard of, considering the full context of scientific debate. Because there's some things that there's one thing that says this and one thing that says this. And this is where courts will still defer to agency expertise on matters of science. It's where the agency has this conflicting report to what they want to say, and they don't consider it at all. Or they write it off in a single sentence. Or it's not rational why they're not using it. Or they haven't presented a reasonable explanation for why they've decided not to use a study. That's where they get into the arbitrary and capricious standard.
So did they get into the arbitrary and capricious standard with this specific thing, or it's because they countered the science with an internal memo that was X amount of pages long, that they don't have to follow this science, but they do have to revisit this at some level, right?
So we argued that they can't rely on an internal memo.
An internal memo. Okay.
Right. And sorry, we're getting into the weeds.
That's fine.
This was another internal inconsistency, was published data and unpublished data, published studies and unpublished studies. So in some instances where an unpublished study supported the service's desired outcome, they used it. And in other instances where an unpublished study supported an outcome the service did not desire, they said, we don't use unpublished data.
So again, double standard of published versus unpublished. And this also goes back to, I think, what some of Judge Molloy's issues were, is that the consistent inconsistencies in the arguments about using data sets or using things like that, and seeing why this is a problem. Now, when you look into that data, then this obviously feeds into the population estimates that we talked about: overhunting, higher quotas, viable population thresholds, which many that are listening to this have known probably since reintroduction started in 95, 96, that it's hard to place a number on a viable population because that was done early on. And now those numbers obviously get revisited over and over again about, well, if we hit the minimum threshold, well, it's still a threshold enough. So what was this thought there about the agency saying, or some of these states even saying, this population can go down to this minimum threshold, still survive because wolves are resilient? And that's part of what I heard in the hearing too. Wolves are very resilient. Even if they get close to extirpated, they'll rebound. Where did he come in on these types of issues too? I guess either was it just more inconsistency, or what was he looking at, talking about current as to historical, and why these numbers don't add up?
Kind of all of the above. So your question covers a lot of ground.
Got it.
So when it comes to the services, the Fish and Wildlife Service's consideration of Montana's population model, IPOM, and Idaho's population model, which is called a space to event model. Scott Creel, I think his first name is Scott, he didn't publish, an unpublished criticism of both of the models, and said, look, this is all the things that are wrong with how the states are using the models. Very detailed, very comprehensive, and it's unpublished, but we still submit it to the record. It's well known in this space, and the service didn't acknowledge it because they said, well, it's unpublished. So this was the thing where it's like, no, if you're going to use unpublished data to discount von Holt, you need to use unpublished data even if it doesn't support what you're trying to do. So because, even though the defendants, the feds, acknowledged there were criticisms of the model and that Idaho and Montana are likely overestimating the wolf population, they were like, well, these are still the best available science. There's no published estimates of potential bias in the models. So there's nothing we can do to figure out if they're accurate or not, and we can't correct them. And the judge said, well, you have to consider this unpublished study because you did elsewhere. And it gives you exactly what you're saying you need, which is a way to correct the estimate. So that's what happened with the models used in Montana and Idaho. But the uncertainty of the models and the uncertainty of what the populations are in these states came in through a lot of the rest of the order after this, because the service relies on, despite all of the killing and all of the increased killing and all of the mismanagement by Idaho and Montana and Wyoming, the Western population is going to be fine. We don't need to list it because there's high dispersal, there's high connectivity, there's abundance of prey and habitat, and it's still expanding. And we can, these states have committed to stopping public hunting and trapping if the population gets down to that threshold of 150 wolves. So we can assume that that's going to happen. And so we don't have to consider these other threats. But the judge said, there's no reasonable basis to assume that the states are even able to know when they've reached those thresholds because their models overestimate and their models are not very reactive to localized changes. So if a whole part of the state of Montana, its wolves get wiped out, IPOM's not likely to pick up on that. And so basically all of the uncertainty in the models fed into Judge Molloy saying we can't really rely on the states to manage at above this legal threshold. And the service wrongly assumed that we could rely on that.
Right. No, that makes sense. And I think this comes also down to one point as well, as we talk about mostly Montana, Idaho, and Wyoming. And we see even the dispersal, right, of some of the Colorado wolves going into Wyoming and being killed.
Yeah.
So was there any thought process from Judge Molloy in the way that, because this really becomes a state management issue and how those things are being managed and looked at federally? It's almost like you go, like you were just saying before, is that the federal agency is relying on the states that have the power to manage these species in a way that is going to be positive for those species to recover and ultimately thrive and survive. So was there any look specifically at even Wyoming and the way that 85% of a state that has viable habitat is essentially a place where that connectivity happens very rarely in a way for them to make that connection to all these the larger populations, which are in Idaho and Montana? Was that in the ruling at all or not?
A little bit.
A little bit. Okay.
And that was when talking about like the viability of Colorado. And, it took how many years for wolves to just get into Colorado because they just get killed in Wyoming, and cutting off like that genetic connectivity and the dispersal between the two, and how that's a threat to the future population, and the service didn't really contend with that threat.
Okay.
Yeah.
So he did talk about that and all that. And this obviously goes into, we look at the urbanization of America and of the states, of the contiguous states, and how people are still even pushing westward at this point. More people, I think, are moving out to the western part of the United States and getting away from cities and things like that. And this feeds into not only the land part of it, it talks about, where are wolves going to go? Are these lands protected? Are there enough wolves to ensure genetic diversity? There's just a lot of factors here. How did it address, because I think I touched on it before and you might have said it, so please remind me if I'm wrong here. How did it address the ruling itself from Molloy about wolves and their resilience? And the way, because there was a part in there and I didn't put it in there, so I apologize for those who are listening, but there is a section or a part or a page where he specifically points that out. I think that the agency says, well, because wolves are so resilient and because they can rebound, as you stated before, Lizzy, they'll survive on their own. But that doesn't mean that we'll have the healthy genetic population that's needed in order for that to survive and not have a host of other maybe medical issues that crop up that wouldn't have happened before. Did that get addressed? I think it got addressed, right?
So that's kind of two issues. So that we do have like the genetic discussion, and then have like the assumptions that the service wrongly relied on.
Got it.
Discussion, which is assuming connectivity is going to stay the same, and dispersal is going to stay the same, and habitat availability is going to stay the same. And then projecting that way into the future and being like, well, they're fine. Obviously, that's incorrect. And then when we are talking about genetics, like that was our group, Matt Bishop. We focused a lot on population genetics. And this is, I don't know if you want to get into like the 5,500, 100.
Yeah, please go ahead. Explain that, please.
Yeah. So the larger conversation here is like, when we look at population size, we have an effective population size and we have a census population size. The census is the whole population. The effective population size is the number of wolves that are successfully breeding. Typically, according to Bridget von Holt, that and others, that tops out at about 10%. But I'll get into that a little bit more.
10% of the entire of the census population.
Yeah. Yes.
Okay. Got it.
Yes. So then we also have the 5,500 rule and the 100,000 rule. So basically, these are different numbers for the same thing. So the first number, 50 or 100, would say for an isolated population, that's the number of individuals needed to avoid genetic harm in the short term. And then the second number, 500 or 1,000, is the number of individuals needed to retain like enough evolutionary genetic potential to be healthy in the long term. The 5,500 rule is what the service used. But as Judge Molloy and we pointed out, and I think others who commented, is professionals in this field stopped using that like more than 10 years ago in favor of the 100,000 rule. Which was another internal failure to explain what the agency was doing. Because they're like, yeah, we have these two things. We're going to use this one, even though it's outdated. And we don't explain why.
And that's a failure of the agency not enforcing it on the states, or who's not using the correct thing in that instance?
The agency, the Fish and Wildlife Service. Yeah. So this whole thing is like their analysis of the current and future wolf population in the West, considering all of these factors, including what the states are doing, including, what's going to happen genetically, things like that. So the service takes all these numbers and runs all these models to say, well, if there's this many wolves and then we increase human-caused mortality by this much and we have a big disease event, like, worst case scenario in 100 years, this is what we could expect. It's not that bad, totally fine. So we're challenging like their analysis to get to those determinations. And they use this 5,500 to basically set a benchmark for what is genetically healthy in the Western wolf distinct population segment. And then be like, look, we meet the threshold. But that threshold is like way outdated. And the best available science that we think they should have used says this is wrong. You should be using a different ratio, which says 10% is like 5 to 10% is what we're looking at for the proportion of the census population that is breeding. Got it. But they're saying, no, it can be much higher. Like the effective population is much higher than that.
Right. Okay. And that's the thing. It's like the argument that Molloy took the side of, obviously, is that there needs to be a higher population for both not only genetic diversity, but for the thresholds of any major catastrophic event that they can't foresee, whether, like you said, weather, disease, overhunting, whatever it is. It's like, you have to have, if you want the population, it seems, from his perspective on this, and I think what you guys are arguing as well, is that if you want this buoying effect of a population, there has to be enough of a population to buoy if there is some catastrophic event.
Right.
Because if you're underestimating and you have a catastrophic event, whether it's human caused or otherwise, you are in serious danger of this species going extinct or being extirpated somehow, and it not being able to recover in a healthy manner, because then the genetic diversity will be completely lost and struck from the landscape.
Yep. Yeah. And according to their own data, the service's own data, they were like, yeah, we do project reductions in population, which may result in the loss of genetic potential, but we think it's fine because there's a connected Western metapopulation with high dispersal rates. And so that's where, again, they continue to rely on these assumptions that aren't safe to rely on to say, well, even though our data shows we may lose a little bit of genetic potential, it's not that big of a deal. So the judge here was like, no, your own data says that there's a threat to the genetic health of the population in the long term, and you didn't really explain adequately why that's not like a bigger deal.
He did. I did notice that with him, is that he did mention a few times in this ruling that nobody's looking at their own data, or he recited their own data, stating it shows here that this population can't withstand X, Y, or Z. So it was for 105 pages, like you said, there's a lot in there, but there were some very striking moments from him that he made it pretty clear where he was at. There was one point though, in this, and this is more towards the end, and we're almost through it, people. So, I mean, I hope you guys are following along. This is really, to me, this is really interesting. And this is how we get to understand where people's mindsets are and understand how to help whatever species you may be thinking of if it gets in a situation like this. But in this, Molloy stated that wolves do not face extirpation with everything laid out. So what was that? That was more towards the end of the ruling, I think. It was towards the end. What was that statement with everything that we just covered and everything that he laid out? Why was he so sure of making that statement after everything that he heard to be able to make that assumption or to make that ruling, part of his ruling?
Yeah, so this is the part of the argument where we're talking about the current condition of what's happening with wolves in the West. And we argued the Fish and Wildlife Service didn't accurately represent the current condition. They didn't consider all of the threats to wolves posed by a declining population. When packs get isolated, that presents new threats. They're only in a tiny portion of their range. And then in the serious threats from human-caused mortality. And the feds said, we did consider these issues, but there are high levels of connectivity and dispersal across the West. Even if populations are declining, they don't currently face extirpation. And this is where the judge said defendants have the better argument for the present. Because the service, in Judge Molloy's opinion, did not misrepresent the status of wolves in the West. They acknowledged a declining population. They acknowledged that a small proportion of historical range is occupied right now. The majority of wolves are in the Northern Rockies, acknowledged the threat of human-caused mortality. I think the significance of him, agreeing with the defendants, the feds, that wolves don't face extirpation right now is neither positive nor negative legally speaking, because what we're looking at is listing under the Endangered Species Act. We want gray wolves in the western United States to be listed as threatened or endangered, which doesn't necessarily require that they're on the brink of extirpation.
Okay.
At the present time.
Sure.
And while he agreed with that, statement that, look, yeah, we're killing all these wolves and we're doing these really horrible things, but they don't face extirpation right now. A lot of the order is also there are a lot of threats going on here. We cannot rely on, continued connectivity between all of these states because we're going to see way more killing. These states in Idaho and Montana, they are politicized. They are, coming after wolves in a way that the service needs to contend with. We can't rely on what they're saying. So I think that was kind of a give and take, but
okay. So it was more him recognizing or saying that the feds recognizing or acknowledging the problem.
Yeah.
And that was essentially why he goes, you're not just blanketly saying these animals are fine. You're acknowledging that there are population declines, there are all these other things you named before. So that in and of itself says that you're acknowledging, I think, it at the most base level that you could. The base argument you can make is, yeah, there's some stuff that's happening that's not healthy to the population. And we acknowledge that. And that's basically what he's saying.
Yeah.
Okay. So going forward with this ruling, what were the implications that Judge Molloy has now laid out for the defendants, the federal government now going forward? Now I believe there's a certain time period for them to have to come back and make either different arguments or say that they've done their due diligence for certain things. Explain what happens after this process is, because we're already roughly 15, 16 days after Judge Molloy's ruling has happened. So what's now the next legal step that's going on for both plaintiffs, defendants, and how this shakes out for the wolves on the other side.
Yeah. So the judge said, you guys, the Fish and Wildlife Service, you messed up. You missed a lot of these things. A lot of these things in your analysis were wrong. And therefore, I'm going to vacate or, cross out with a red marker your finding that protections are not appropriate for the Western distinct population segment because your analysis to support that wasn't good enough per the ESA.
Got it.
So that's been remanded to the agency. So basically, cross out, give it back, do it again, and fix all of these things that we just talked about where the agency got it wrong. The papers that they didn't contend with or assumptions that they made to support their conclusions, which are assumptions that they shouldn't be relying on. So they need to go back and do it again. And generally that's 12 months. The asterisk is appeal. So there's a lot of defendants, including the federal government, but also other groups intervened, including trophy hunting groups like the Safari Club, the Sportsman's Alliance. The state of Montana also appealed. The state of Montana intervened. I think Utah intervened, and Montana Fish, Wildlife, and Parks intervened. The trophy hunting groups have appealed because when you're an intervener, you have that power. The federal government has 60 days from the ruling to appeal to the Ninth Circuit Court of Appeals. So, I will not be surprised in one bit if the feds appeal. Things in the Ninth Circuit take a couple of years. So what will probably happen is if this gets appealed by the federal government, we're looking at a couple years in that court while the decision by Judge Molloy will probably get stayed. Because if the Ninth Circuit is considering, this finding that the agency got it wrong and needs to go back and redo it, like when in court, you stay things when you need to preserve the status quo, because it wouldn't make sense for the agency to go back and redo this whole thing and then the Ninth Circuit be like, that wasn't necessary because we disagree with Judge Molloy's findings, which is possible on appeal.
Okay.
But
so legally we're talking about this was a ruling that's now going to set in motion other hearings or rulings.
Most likely.
Where we won't get, because I think what happens, for myself included, and I think when anybody sees a ruling of something like this, you go, oh, it sort of fixed the problem. And it's like, no, this is like one step of probably 12 steps.
Yeah.
It's like a 12-step program almost to get to the eventual end goal. And there were people will have the argument then who are looking to, and it's not just wolves, it could be bears, it could be anything else, is that by the time this comes to fruition, whatever the ruling may be, the population could be decimated beyond repair.
Yes.
And so, to be fully transparent, is that something that is plausible, or is that something that, in other words, if people look at this as a little bit of hope for the population and management, and saying these things were wrong, judge said to go back and redo these things. Now there's litigation, all things like that. What's in your legal opinion, where could we end up, say, in those 12 months? What could you foresee as being the next steps, and what could possibly happen here?
Very good question. So this ruling didn't change the current status of any wolf population. But had we not won, the Northern Rockies would not currently have the chance that they do to ever get protections again.
Sure.
Outside of
Absolutely.
a completely separate additional process.
Sure.
So there's that. Yes. In the next 3 years, per Montana FWP's own data, at the numbers that they're killing, we could see population declines to an unsustainable level. The tough part is that this lawsuit is against a federal agency. And their powers essentially would be to, like, you know, there's an emergency listing provision in the ESA, like, but we're also looking at a Trump Fish and Wildlife Service, which I think is extremely unlikely to relist wolves. So in that sense, we may benefit by a longer time period with the appeal. But like you said, wolves on the ground are suffering and dying in droves in Idaho, in Montana, in Wyoming. And this ruling has not changed that. And because it's the states that have that power, we can't do much in the Northern Rockies with the federal government or the federal laws because they don't have the protection of the federal government or federal laws. Right. This is why Wild Earth Guardians, I think at least one of the last podcasts we did on here, maybe the other two podcasts I did on here, we are suing Montana in state court. And we have been since 2022. To say that the way that they're managing wolves per state laws in our state constitution is illegal. Because they have these duties not to degrade the environment. And like wolves are a public trust. And what they're doing is not at all managing for the public. You know, so we knew that, one, this case could have been a long shot. We won. That's incredible. And it's just the start of a long process to potentially get wolves reprotected under the Endangered Species Act. There are no guarantees that that will happen, even though we think that's the right course of action based on the facts and the law before us. Because of all that uncertainty in 2022, we were like, we're doing whatever we can. Like, somebody needs to do this. Somebody needs to take Montana to state court because we can't count on the federal process to protect wolves in Montana. So that's what we're doing. And this coincides with like the current season setting process that's happening in Montana. Like you said, Thursday is the Montana Fish and Wildlife Commission meeting. They have proposed the worst things I have ever seen, which is it's a low bar in Montana, as we know. They've proposed the Fish and Wildlife Agency that's supposed to manage these species has proposed to kill 500 wolves. They've made a whole slew of proposals that are going to be absolutely disastrous for the wolf population. And especially if, you know, looking at some of the scientific articles that have looked at the problems with IPOM and said, you know, we're looking at like 150% overestimation bias, which means we may have a population of 700. And then FWP is over here saying, let's kill 500 via hunting and trapping, and then let's kill another 100 via like controlled removals. So wildlife services for livestock purposes, or landowners can kill wolves that they determine as a potential threat to livestock, dogs, or people. And as of this year, so in 2021, Montana changed its laws to say bounty payments are available for legally harvested wolves. So that's hunting and trapping. In 2025, they expanded that law to say any lawfully harvested wolf, which is hunting and trapping, and also wolves killed under that landowner provision. Usually, only like 10 wolves are killed under that authority. Now, landowners can get minimum $1,000 for each wolf killed that they determine as a potential threat, which could be anything. Wolf, I saw a wolf in the distance. That's threatening. Like, we've heard people say that about grizzly bears because this has come up in the grizzly bear context too. So essentially, Montana has proposed quotas of 600 of a population that could be 700. And, you know, we already have talked about all of the tools that are available to do the killing. And it's really dire. This is really, really bad.
Yeah. It's a bad, I mean, it's a bad situation that, I mean, I was making comments the other night on these amendments that were coming forth for Montana Fish, Wildlife, and Parks. So, I mean, it's good to know that yourself, Wild Earth Guardians, and a bunch of others are taking the state to task. And I think for anybody who's listening to this and hearing, obviously, the statements that Lizzy just made, I mean, these situations obviously are dire, but those that want to get involved, I think, is to help support Wild Earth and to see what's going on. This really comes down to looking at your state level actions and what it actually means. And I think some of what gets caught up here in the crosshairs or the crossfire of all of these things that happen on a higher level, whether it be state level politics or federal level politics, is that for the most part, I think there's the majority of populations in some of these states tend to disagree with a lot of what is going on in a lot of these management practices. You're seeing this in Wyoming where they're still talking about bringing charges against, snowmobile, with Cody Roberts and things like that. So the wheels of justice turn slow. I know that was something my father-in-law always told me. So it's one of those things that, change may ultimately happen, but not as quickly as we like. But it's always good to keep fighting,
Yeah, we got to keep it up. Yeah, I will say suing in state court is very expensive. So so we have a wolf defense fund. If you feel called to contribute to our legal efforts, I mean, they're going to continue no matter what, but the more people we have behind us and supporting us, the more we can do. And we're one of 4 groups that are part of this lawsuit, and we're kind of spearheading it. Us and Project Coyote were the first groups to sign on. And when we were talking about this in 2022, a lot of people wouldn't touch it and said, no, that's, too risky or too expensive, or, state court is not something we do, or that's a bad idea. And now a lot of people are saying, isn't there a lawsuit we can file? And it's like, yes, there is. We filed it. So yeah, we could really use support. And I think too, this is hard work, emotionally, as I think anyone who's invested in wolves and cares about wolves in this political process, and just the harm and the cruelty that we see, and the wheels of justice turn slowly, if at all, when it comes to species like wolves. And it's just, sometimes it feels like one step forward, 2 steps back. And, I think the more we rely on each other and the more we talk to each other and the more we share these things, the better. I had a summer intern, and this was her introduction into wildlife advocacy. And I think any sort of environmental advocacy, but particularly wildlife advocacy, really can take a toll. So it's important that we all take care of ourselves, and, we do the work, and we also stop doing the work at a certain point and go do something else. Yeah,
you need that you got to have self-care in these types of situations, in order to be fresh and be able to have different perspectives. And we've hit the drum so many times on this podcast. It's really about compromise and communication and talking with one another, and that these are big issues that can be tackled with many different folks from many different angles. And, it's sometimes talking to the person on the other side that might not fully agree with you on 1 or 2 things, but may come to a compromise with certain things. And I think that's ultimately where we still have to get. We're slowly, hopefully getting there, but we'll see. So wildearthguardians.org, right, Lizzy, where they can, or so I asked her the website.
Yes, wildearthguardians.org.
wildearthguardians.org. So obviously, we'll have the whole ruling from Judge Molloy in the description podcast. Will have the link to Wild Earth Guardians, so you guys can see what Lizzy and her other compatriots are up to. Thank you so much for going through this entire ruling with me and for everybody, so they can understand it, what's going on, and what this actually means going forward. Lizzy, really appreciate you. You're the best. Thank you so much.
Thanks. It's good to be here. I love talking about nerdy legal things, so thank you for giving me a platform to do so.
Absolutely. Anytime to talk nerdy legal things, this is the place to go. Man, just hang tight while we sign off. Howls to you all out there, and we'll be with you next time. Bye, everybody.
Looking for more information about Wolf Connection or the podcast? Visit our website at wolfconnection.org, where you can donate, sponsor a wolf, or become a volunteer. Thank you for listening.